Hello, I'm Blake West with Alabama Estate Planning Attorneys. Welcome to this webinar on 3 important documents to safeguard seniors. Actually, these documents are good for many of us. So let's get into the presentation. Here are our documents. All right, let's look at our problems. What kind of problems? We need assistance as we or our loved ones age. We want to maintain our dignity as we age. This is one of the most important things about our lives. It's maintaining dignity. It's one of the reasons that I began doing what I'm doing, because you see what happens to people who have not planned, who end up in probate court with a guardian, conservator appointed, being a person that they do not know, someone that they haven't chosen, and it's a mess. So and it takes away your dignity. If you have a guardian appointed, that means the guardian makes all those decisions for you. Who you see, where you live, nursing home, at home, who gets to see you, lots of decisions that need to be made that we want to make ourselves to maintain our dignity. And how can we do this easily, privately, and without going to probate court? That's the things we're going to look at. All right, the solution to that is power of attorney for healthcare, advanced directive, or living will, also sometimes called a natural death declaration. All right, a power of attorney. That's a document signed by the principal, the person who needs or may need assistance, that allows the agent, the child or other loved one, someone trusted, to conduct business for the principal, for generally the parent or an older person. Who can make a power of attorney? Anyone who has the capability to understand the document can do that. Is this possible after the doctor has said, listen, your mom has a little dementia, or she has Alzheimer's, she's forgetful? The answer is yes. They can still have capacity to execute a power of attorney, maybe a will and a trust as well. Just because they have a diagnosis of that does not mean that they are totally incompetent and incapable of doing things. And this is what it would look like. The principal or parent here, via power of attorney, gives power to the agent to speak with banks, a facility, assisted living facility, other places, utilities, anything like that. Now, that does not eliminate the principal or parent being able to do this also, because in the beginning, when you have a power of attorney, usually you want to be able to still do this for yourself. But if you can't, we have the agent here that is able to do that for you and to assist you in those things. One of the ways that if I'm speaking to someone about, does this person have capacity, is, does this person know who they are? Easy one, usually. Where they are, a little bit harder. Do they know who they want to assist them? A child, a brother, sister, spouse, whomever that person is. Can they describe who that person is to them? And a little bit about what they have. They don't need to know bank balances, but I have a bank account. I have a CD. I own a house, just things in general. And if the person knows that, that person can execute a power of attorney without any problem. All right, and who needs it? As I said in the beginning, anyone who needs a caregiver would certainly need a power of attorney. Even if you don't need it the day you sign it, which I hope you don't, you may get into a position where you need it. And if you wait too long, you might not be able to execute one. You might not have the capacity or have the ability to do that if you wait too long. And it works with banks, financial institutions, anyone with whom the principal does business should be provided a copy when the time is needed. It can be recorded at the courthouse. That does not actually give it any more authority, but if it's recorded at the courthouse, you can use a copy, and most of the banks, financial institutions, and other people think that it means more if it's recorded at the courthouse. All right, does this come without any problems? No, this can come with problems. Power of attorney can be a blank check. You give power of attorney to your child, the child can go to the bank and empty the bank account, can sign deeds for you, can do those kind of things. And another possible problem is we'll have a power of attorney. It was done several years ago. Well, the power of attorney law changed January 1st, 2012. And so that can cause some problems. So you need to think about that, have an attorney look at what that power of attorney says, and make sure that it's still sufficient to cover the things you need. Because some of the things that changed are some of the things you need, especially as you get older, and in case you need more medical care, or if you need nursing home care. Some of those are the main issues that changed. All right, how can we prevent some of those problems? Well, one of the ways to prevent that is you have two agents. If you have two children, you name them both, and they both have to sign to be able to obtain financial documents, move money, take money, sign deeds, and that sort of thing. If you have three children, you can put all three and say that they only have power when acting by majority. It takes two of them to act. Another thing is you would probably name your spouse as your primary agent, but your spouse is probably close to your age, maybe soon experiencing some of those same problems. So we would also name a successor to the primary agent. Now, the successor agent, the way it's written, does not have any authority until the primary agent, the initial agent, is either deceased or unable to act, refuses to act, or just signs something that says, I don't want to do this, I can't do this, I want to pass this to the successor agent. Another important thing to remember about the power of attorney is that the power the agent has dies when the principal dies. If a child has power of attorney for a parent, that parent dies, then that agent no longer has any authority. Can't go in after mama's died, sign checks, take stuff out of the house, sell the house. When the principal dies, the power is over. All right, document number 2 is a healthcare power of attorney. All right, it's the same type of thing. It's a document signed by the principal, a senior, or whomever the person is, that allows the agent, a child, spouse, trusted friend, to make medical decisions if the principal is unable to do so. It also allows, and this is the more important use of the healthcare power of attorney, is it allows that agent to receive information from medical providers and caregivers. If someone's in a car wreck, they go to the hospital, you go up there and you say, hey, my wife just came in an ambulance, she had a car wreck, how's she doing? Well, I can't tell you. Oh, I forgot, here's my ID, that's my wife. I'm sorry, what's going on? I still can't tell you. Because if the person who is in the hospital, who's injured or sick, is unable to authorize at that time the hospital to provide you information, the hospital will not do it usually. So if you have this healthcare power of attorney either on file or have one with you on your phone, or can get one sent to the hospital, then that document will allow the hospital to tell you, the agent, what's going on, what the person's condition is, and give more information about that. The hospital may not even tell you if the person is there in the hospital. So who can execute a healthcare power of attorney? Exactly the same, really, as the power of attorney. Someone needs to know who they are, where they are, if they have some sort of a condition already, a little bit of insight to that, and they need to know the person that they want to make their agent. If that person is a spouse, child, be able to name that person and relate the relationship and say that, yes, I want this person to make a medical decision if I cannot make one for myself. Now, the agent can never override let me start over. The agent can never override a decision made by the principal. If the principal tells the doctor, I do not want that treatment, I do not want whatever, I do not want that shot, I don't want it, and that is a medically reasonable decision made by someone who is aware of what's going on, then the agent can't come in and say, give it to them anyway. Now, can the doctor ignore any refusals? Yes. If someone is hysterical, or they're very sick and they don't know what's going on, they have a bad UTI, acting a little bit incoherent, they're on pain, the person's on pain medication to the point that a rational decision can't be made, then if the doctor feels like that is not an informed, rational decision, the doctor could go to the agent and ask the agent what to do in the situation. Who needs one of these? Almost everyone. Accidents and injuries happen every day. And if someone is in the hospital, cannot communicate, then the hospital cannot give out information. The hospital or any medical provider would have to have an authorization to release that information. That comes through the HIPAA Act. All right. And this document would provide that authorization. And it is portable. It could be used for any medical provider, and you don't have to have a different one for each hospital, each doctor, or anything like that. All right, and this works the same way. We have the principal, a parent here, the agent, typically a child, through the healthcare power of attorney, has the authority to talk to the medical providers, a caregiver, hospital, whomever it might be, and make a decision if a decision needs to be made. But that only comes if the principal or the parent is unable to make a decision for him or herself. Cannot override the parent. Possible problems here. Well, the agent can receive information about the principal, about your parent typically, with or without the principal's knowledge. So, dad goes to the doctor, has a doctor's appointment. You think he's been sick, he's having some problems. Comes home, hey, Dad, what'd the doctor say? Oh, doctor said I'm fine, perfectly healthy, not a problem in the world. So, and you don't believe that. You go, well, okay. So then you call the doctor yourself. Hey, doc, my dad says that you told him he was perfectly healthy. Is that the truth? And if this is on file, they have the copy of the healthcare power of attorney, then the doctor could tell you, no, I'm sorry. I told him he has pancreatic cancer and he doesn't have long to live. And he said he didn't want to have any treatments. So then you could take it up with your dad. But that would be the only problem I can think of, is if you had a medical condition that you did not want others to know about, or your agent to know about. If you're at the medical provider, when you get that, you could revoke it at any time. You could say, listen, I know there's a power of attorney out there, but I am revoking it. Don't tell Blake any of the stuff that we just talked about. And the provider would honor that. And an agent cannot override the decision of a principal. So whatever the parent says, as long as it's a coherent decision, even if the agent doesn't think it's a good decision, you can't override it. All right, the third document is a living will, a natural death declaration, a healthcare proxy. I typically call it an advance directive. All right, now this document is a very narrowly tailored document. You have to be in this little bitty box for this document to apply. Healthcare power of attorney covers everything. Very broad document, covers many, many things. But this is very narrowly tailored document. And the second paragraph of that document says that this document will only be used if I am unable to speak for myself. And that would include nodding, blinking, squeezing hands, whatever way you could communicate. If you can communicate, then the advanced directive would not apply. All right, and it's a document that describes how you would want to be treated or not treated in a limited set of circumstances. Easy way to say that is you're terminally ill or injured, very sick, and you're going to die in the near future. Then your heart stops, you stop breathing. What actions do you want taken, or what actions do you not want taken? It would also apply in the case of permanent unconsciousness, often called a vegetative state. So it would apply for those purposes too, because if you're the case on TV that we saw a few years ago, Terry Schiavo, a lady in Florida, had an injury. She was a young woman, and she wasn't brain dead, but she was permanently unconscious or in a vegetative state. And she lived, and they fought in court for years. The husband and her parents fought back and forth because she did not have this document. And so after several years, the husband prevailed, and they terminated her intravenous fluids and feeding tube. And then she died a few days after that was stopped, obviously. So it also covers that situation. Now, some people say, yes, I want to have the feeding tube. I want to have IV fluids. I want to have all those things. And whatever choices you make on this document, there's not a right or wrong answer. Whatever choices you make are the right choices for you and your family. Now, this is typically talked about, if you're in the hospital, you're on hospice, if you're having a medical procedure, they ask you about these documents. Now, this document is different from a DNR. Now, a DNR to me would only be appropriate if you're in the nursing home or you're home on hospice or something like that. Because the DNR means they're going to do nothing at your direction. Your heart stops, they're going to watch you finish dying, or they're just going to watch you. This document is not a DNR. Not at all. This is similar, but it's not the same thing. Again, who can execute this document and who needs one? Virtually everyone needs one, especially those who have a caregiver or in declining health. It can be executed by anyone who can understand the document. Do you know what you want? Do you understand what it means if you do not receive life-sustaining treatment? Do you understand what it means to receive life-sustaining treatment if you're in a terminally ill condition? So anyone that can understand that can execute this document. And it's a very important document to have. Possible problems, the only one I know of is your medical provider wouldn't have a copy of it. Now, when we do things in our office, we do these plans or a full estate plan, we always provide extra copies of the healthcare power of attorney and the advanced directive to make sure you can give them to your medical providers. We keep an electronic copy. We send you an electronic copy that you could send to your agents or whomever you needed to have one. That's about the only downside of an advanced directive or a living will. All right, now we've talked about 3 important documents to have. All right, this is not estate planning, really. This is a little bit the very edge of estate planning. Now, at Alabama Estate Planning Attorneys, we do all types of estate plans, wills, trusts, etc., whatever you need. We do applications for people going to the nursing home to help save the family some money to make sure that the parent gets qualified for Medicaid. Sometimes that involves an irrevocable supplemental needs trust to have some money available to assist that parent in the nursing home and still be able to qualify for Medicaid. There's other strategies to do that too, burial, vehicle, and spousal allocations and things associated with Medicaid plans. And we do all of those things too. We also have virtual office meetings. We can meet with a client and a child, they do not have to be in the same location via video conference. That can be most anywhere. And it can involve whomever the client wants there. If it just, typically it would just be me and the client or clients. If they want to include a child, a brother or sister, whomever is going to be the agent, that's fine. We can include them. They do not have to be in the same location as the client or the person who's going to be executing the document. Those documents would be reviewed also after they're drafted by video conference. Now, if we're going to sign the documents without you coming to the office, you would have to have a camera so we could watch you sign those documents. Those documents would be delivered to you either via overnight, UPS, post office, FedEx, whatever was the best method, would be delivered to you with a return envelope. You would sign them as we watched you through the video conference. You would put them in the envelope that's already prepared. You put it in there and either put it in the mailbox or call for a pickup from UPS or FedEx, who would come get it, and it would be delivered to us. We would witness and notarize the documents as necessary at that time, make ourselves an electronic copy to keep, and send you the executed notarized documents, send those back to you for you to have with extra copies. All right, what do I do now? Well, what I've learned this, what do I do? You need to decide to take action for your protection or the protection of your loved ones. Make an appointment. You can do that by calling us, 886-2372, an email, aepallc@gmail.com, or you can, if it's convenient to go online, candidly.com/AEPA, and you can set up your own appointment online from the privacy of your own home, and you can do that in the middle of the night, early in the morning, whenever you need to do it. So I thank you for watching this brief webinar. If you have any other questions, need to do something, you have our contact information. Thank you.